Brittany Stevens.
Come on, Brittany.
Good morning, Judge.
Good morning. Good morning, Ms. Stevens.
Judge, the plea will be not guilty on behalf of Ms. Stevens. I did file a designation for Ms. Grosskopf, who I believe represents her on the pending matter. Judge, we would just ask for a nominal bond, given that she's being held already.
Can you state anything?
Your Honor, there is an existing charge for unauthorized use of property. Defendant was rearrested on December 31st for criminal trespass and failing to abide by the conditions of the stay away order on the underlying case.
$500 at 10%.
Thank you, Judge.
Torres, Juan Torres.
All right. All right.
Bench is pretty cool. I just stand right
Come here, Judge.
Oh, yes, okay. Mr. Torres was in my room yesterday and I put him in here so that he can get counsel today.
Okay. Do you have a volunteer on behalf of Mr. Torres?
They told me that was gonna be released today.
Okay. I'm not sure if there are any other cases that you might be released on, but this one, there was $1,000 bond at 10% set back on December 24th, but no attorney was assigned. So did you want to address that bond? It's a reasonable bond based on what is alleged, and I'm not apt to change it, but
If I could
I'll
be
hear
heard,
you.
we would be asking for an OR bond, Judge. Mr. Torres has absolutely no record. The only failure to appear is for a traffic ticket. He's 27 years old. He lives here in Cincinnati. I have good contact information for him. He is a Norwood High School graduate. He has family in the area. I also have contact for his father as well. So we would be asking for an OR bond in this case.
From the state.
State would object to any bond modifications from the December 24th setting. Allegations are that he threatened the prosecuting witness with a BB gun that looked like a realistic firearm. State believes that the bond is reasonable in this case and should not be changed.
It will be the same bond.
But it doesn't say so.
Last name Nkingi, Nki. Domestic violence protection order requested. I don't think they have one there anyway, so.
Judge, if I may just have a moment with him on the TPO. Judge, looking at the TPO, it looks like one of his other children is included and his wife. Judge, I would ask that his wife and the other child be removed from the TPO. It's my understanding that the issue is with the prosecuting witness, not with the other children or his wife. There's no allegation that they were harmed or at risk of harm in any way.
From the state.
Your state at this time would object to removing those parties based on the affidavit. Defendant was observed by one of those other children. They are a witness to the case. Allegations are that he struck the prosecuting witness, known as DM, repeatedly with a sandal, causing bruising on multiple areas of the body, including arms, back, and forehead, as well as a bruise around the eye.
Josephina's wife.
Is his
that
wife, that's
correct?
correct.
I'm removing wife. She's an adult. She can seek something on her own if she would like. As to the other child, I am going to take that child off as well. That child, it appears, was present, but that child also spoke to officers and made a statement that dad and the other daughter were slapping and hitting one another while inside the residence, not that it was a one-sided attack. The defendant has no record at all as an adult or juvenile, no prior failures to appear. And the protection order is in place against the daughter that the allegations are against. Is there anything else as to bond?
Esteban, Judge, he does work for a warehouse. He's been working there for 3 months. Judge, I would just again acknowledge 0 failures to appear, absolutely no criminal record, an ORAS score of 2. He has some family support in the area. Judge, I will be filing a notice of self-defense in this case. It's my understanding that this daughter has a history of behavioral issues, and that I think this is the cause of that. Judge, I would ask you to consider an OR bond given that he has no record and executed the TPO.
From the state,
Given that he's executed the TPO, we'll defer.
OR plus the TPO.
Siles, Charlie Siles.
Thank you, Judge.
Judge, this is the Siles. We don't interpret it.
All right, good morning. As to waive probable cause.
Yes, Judge, waive probable cause, plea will be not guilty.
As to bond.
Judge, if it wasn't for the holder that's been placed on Mr. Siles, we would be asking for an OR, considering he has no history, no failures to appear, no misdemeanors, no felonies, extensive ties to the community. He's given me good contact information for his mother and his father, who both live locally in the area. But considering the holder, we'd be asking for 1,000 to 10% on each charge.
From the state,
Your Honor, this is an allegation that the defendant was engaged in street racing on West North Bend in Springfield Township. When officers engaged in a pursuit, defendant took off in his vehicle, blew through multiple red lights and stop signs, and ended up turning onto a dead-end street where he was apprehended. We will defer as a bond.
there's no record, no failures to appear. I will put the requested bond on the felony 1,000, the drag racing 1,000, driving without a license. Is that unclassified or?
Believe it's unclassified.
Has he had a license before?
I don't have those records.
OR.
Grand jury report date January 12.
Is it on everything?
Yes. Last name Sims, Lavelle Sims.
Judge, so Mr. Sims, the plea will be not guilty, will be waiving probable cause.
All right, Esteban.
Judge, as to bond, Mr. Sims is relatively perplexed as to why the alleged prosecuting witness in this case wasn't the individual who was charged, and Mr. Sims is the one with charges, considering that Mr. Barr, the prosecuting witness, is the individual who shot at Mr. Sims first. He wants the court to consider that heavily when setting bond today, that Mr. Sims was not the initial aggressor, and the fact that the PW in this case fired numerous rounds at Mr. Sims and probably should have been charged instead of Mr. Sims. We're asking for a nominal bond, Judge, $10,000 at 10%, despite the serious nature of these allegations and the high level of the offences. Mr. Sims has an ORES score of 2. He is currently employed with a temp service where he's been there, not very temporarily, for the last 2 to 3 years. He's a forklift operator for that temp service. Before that, he has a long line of history working as a chef. He's a graduate of culinary school. He's lived here all of his life, Judge. He lives by himself in Westwood. But if EMD was a condition, he can give numerous other addresses in the area, family members who can take him in if EMD was a component of that bond. That just shows his extensive ties to the community. And in relation to the danger to the community, he hasn't had any charges since 2018. He's been staying out of relative trouble for the last 7 years. So we'd ask the court to take that into consideration. And the fact that Mr. Sims was not the initial aggressor, the prosecuting witness was. And obviously we'll be filing a notice of self-defense if it gets to that stage. We'd be asking for a $10,000 at 10% bond on these charges, Judge.
From the state?
Your Honor, state will be asking for a high secured bond by the defendant's own admission. He did shoot at the prosecuting witness, Mr. Javante Barr, then also admitted to officers that he threw the firearm in the river after shooting at that victim. Defendant is currently under disability due to felonious assault conviction with a gun spec in '98. Also has convictions for weapon under disability and improper handling of a firearm in a motor vehicle, both of which occurred in 2016. State again is going to ask for a high secured bond on this case, as well as an order for no firearms.
On the tampering, 10,000 anyway. On the having weapons while under disability, 25,000 secured plus EMD. On the felonious assault, 150,000 secured plus EMD plus juris if requested.
Grand jury date, January 12, 1/12.
City domestic violence docket.
Randy Yang on behalf of the city. Your Honor, petition called Jay-Sean Club. There's an order of protection requested. Is this an Adriana Harris here today?
Elizabeth Sanders for Mr. Clark, and not guilty for Mr. Clark.
As to bond.
As to bond, Your Honor, Mr. Clark is 36 years old. He works at the Kenwood Movie Theater and has been there for over 6 months. He and the prosecuting witness do not live together. He has no problem signing a TPO. And I will also be filing a notice of self-defense. He has no violent convictions on his record and no prior DBs. There are past charges that were dismissed against Ms. Harris for assaulting Mr. Clark. I would be asking for an OR today, Your Honor.
From the state.
From the state, Your Honor, we asked today to monitor bond based on the allegations, they are the violent allegations that he punched the victim multiple times during a full verbal argument.
Mr. Clark has 6 prior felonies, 2 misdemeanors, 3 prior failures to appear. The prosecuting witness has marked on the questionnaire that the prosecuting witness does feel safe to remain in the home. With the failures to appear, it will be in the TPO 3,000 anyway, plus juris if requested.
Donzel Fuller. There's no order of protection requested. Today, Kiera Paulman.
Full Elizabeth Sanders for Mr. Fuller. Not guilty for Mr. Fuller.
All right, as to bond,
As to bond, Mr. Fuller is 34 years old. He works at Cincinnati Fans and has been there for 3 months. He's a lifelong resident of Cincinnati. Graduated from Finneytown High School and from college in 2021. Evidently, Mr. Fuller and Ms. Palmer were together when he was arrested recently, and Ms. Fuller forgot and intends to dismiss this and forgot that this was even pending because it was from, not from this month. They do not live at the same address, and Mr. Fuller has 2 failures to appear over the last 5 years and doesn't have a problem signing a TPO. He will show up, and we do think this will be dismissed. I would be asking for an OR from
I
Mr.
have
Fuller.
the date of incident 1/3/26. On both.
I'm sorry, Your Honor.
Nah, this just sent from last night.
Sorry, I got my dates mixed up, Your Honor.
The parties do not reside together,
Correct, Your Honor.
and Mr. Fuller is executing the TPO
Yes, Your Honor.
from the state.
From the state, Your Honor, based on the allegations, they are violent allegations, we'd be asking for the monetary bond. Officers stated in the complaint that this was caught on video and there's a visible injuries to the victim's face and neck area.
There are 2 misdemeanors, 2 prior failures to appear, no violent convictions. 1,500 anyway on each count plus juris if requested with the TPO.
10%, 1,500, so 300 total. All covers this year. Your parents are mentioning.
Yeah.
Okay, I'll share. Okay.
Devontae Mallory. There is an order of protection requested. Today, Mila Crawford.
Elizabeth Sanders from Thank you. Not guilty for Mr. Mallory.
All right, as to bond,
As to bond, Mr. Mallory is 29 years old. He is a lifelong resident of Cincinnati. And as I misspoke last time, this is from earlier in December. And we also think this one will be dismissed as they were together when Mr. Mallory was arrested, and the prosecuting witness intimated that she'd forgotten that this was out there. We would be asking for, he's executing a TPO. We would ask if the child was not present when the charge originated, we would ask for the child to be removed. But he is okay with executing the TPO.
this is a shared trial
Yes, Your Honor.
from the state.
From the state, for the students will subject any modification to TPO. Second, we would assess the monetary bond again. Allegations are that he struck the victim in the face during a victim statement that, based on victim statement that the suspect punched her in the face, causing physical harm.
I would also know, Your Honor, that there are 0 failures to appear over the last 5 years.
I'll take the child off. There's no allegation with the child. This is an allegation from December of 2025, beginning of December 2025. He's executing the TPO against Ms. Crawford, correct?
Yes, Your Honor.
There is 1 violent felony, 1 felony, 3 misdemeanors, 0 prior failures to appear. Again, this incident was over a month ago. It would be OR plus juris if requested.
Thank you, Your Honor.
And I think that's it for the city DB traffic law.
What I do today?
Oh, I'm sorry, I don't have the traffic. Hold on for 1 second.
Sure.
I need the traffic for, it may be mixed in with the other.
What's the last name they're gonna
Mallory.
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 They're different.
I just have the BB. Were those city or county cases? The traffic.
The traffic, they were city.
They're city or county.
After I'm back, I will go for the call so she can try to bring it back to me.
It's, we'll look for it. It's traffic.
Yes, I have.
There's no failures to appear, so there'll be OR once I get the paperwork.
Okay, thank you.
Thank you, Ron.
County lockup, last name Ashley, Grady Ashley.
Good morning, Your Honor. Angela Glazer on behalf of Mr. Ashley,
Waive probable cause.
waive probable cause, Judge.
All right, ask to bond.
Regarding bond, Judge, on behalf of Mr. Ashley, he is 38 years old from the Cincinnati area. Did obtain a degree in Science and Business Administration from Colorado University, their online program. He also is planning to enter into a carpentry program starting this week with the Osweiler Institute. Judge, he disputes the allegations here. I understand there was a search warrant that was executed. He said he was not present inside of the house when the search warrant was executed. That is where it's his understanding the drugs and the firearm were found and recovered. So he disputes that they were his. It's not his residence. Just asked the court to consider that when setting the bond. Additionally, these are F3 level offenses, Judge, so I'd ask you to take that into consideration as well.
From the state,
Based on defendant's history, we are asking for a high secured bond and no firearms as a condition. Defendant has a drug history that goes back into multiple convictions in 2016 and prior. Defendant also has a weapons under disability conviction in 2019 and a conviction for failing to comply with officers. Based on those allegations, we're asking for a high secured bond and no firearms. Drugs recovered in this case are believed to be fentanyl and cocaine at this time, packaged for distribution.
there are 17 prior felonies, 4 pending charges, 7 prior failures to appear on the A, trafficking in fentanyl. $25,000 secured on the B, trafficking in cocaine, 15,000 secured. On the having weapons under disability, 25,000 secured. The possession, 10,000 secured. Possession of crack cocaine, 10,000 secured. The possession of fentanyl, 15,000 secured.
Grand jury date, January 12th, 1/12. Last name Blackman. Tryon Blackman.
Alright.
Blackman,
Judge, we can waive probable cause for Mr. Blackman.
all right. As to bond,
Regarding bond, Judge, he is from Cincinnati. He's 21 years old. He was attending John Community School until it shut down. He has one child that he shares with his significant other, who is 2, that he supports, and he is employed working with his significant other's father, who has a company that demolishes houses. So that's where he's been working for the past few years. I'm showing one juvenile contact. Other than that, no other convictions. He can do the EMD. He'd ask the court to consider that and the alternative of a high bond, which he'd be unable to afford. He can do the EMD 2 locations, either at his mother's address or with his significant other, where he lives with his child. So we just asked the judge, we'd ask you to consider a low bond with the EMD judge.
from the state,
State is going to request a secured bond and no firearms as a condition. It started out as a traffic stop. Officers attempted to pull the defendant over for failing to use a turn signal. He then fled in that vehicle after lights and sirens were activated. At one point was able to get out of the vehicle, flee on foot. Officers observed a firearm in his hand that was recovered when he was apprehended and arrested. The firearm was equipped with a 3D printed Glock switch and was reported stolen out of District 3 from Cincinnati Police. Defendant made statements to the officers that he believed the firearm was stolen, was also in possession of cocaine. If your Honor does decide to release him on EME, we'd ask that it be EME lockdown.
as an adult, Mr. Blackman has no record. There is one felony as a juvenile, to which it looks like he was just released from supervision less than a year ago. On the obstruction, 1,000 anyway. The failure to comply, 5,000 anyway. The Glock switch, 25,000 anyway. The CCW, $50,000 anyway. The receiving stolen property, which is the gun, 5,000 anyway. The possession, $25,000 anyway. Traffic OR.
Grand jury date 1/12, January 12th. Robert Brown. Brown. Request for order of protection. The retired age of Brown.
Good morning, Your Honor. Kamal Castellan for Mr. Brown.
Waive probable cause.
Yes, Your Honor.
Esteban.
Mr. Brown denies attacking the victim here. He was helping his daughter move into a family residence building, and a dispute broke out where they started having an argument. Mr. Brown does not live with his daughter. His daughter does not live in the same unit. He tells me that she is more than likely not going to be staying in the same residence. He's willing to stay away from her. He's executed the protective order. Other family members live in the same building, and they're the ones, he's told me that they're looking to try to find an alternative residence for his daughter. Mr. Brown lives here in Cincinnati. He's been working a few years at Alliance Academy Kitchen. He has another shift on Monday. We're asking for either OR and EMU or a low bond in EMU in this case.
From the state.
Due to the nature of the allegations, Your Honor, state will be requesting a secured bond as well as no firearms as a condition. Allegations are that he did place his hands around the throat of his daughter, Tyrasia Brown, and then squeezed her throat, cutting off her air supply. These were based on statements made by the victim to police. If Your Honor does decide to allow him out, we would ask for juris monitoring as a condition.
Mr. Brown, it appears is, I'm not great with math, 41.
Yes, ma'am.
No record as an adult or juvenile except one minor misdemeanor weed ticket from 2007. He is executing the TPO, has a separate place to stay, no failures to appear, and there was not a DV form that I have, unless the state has one, a victim's rights form or anything where the alleged victim is requesting something or stating fear.
I don't have anything at this time, Judge.
Supervised OR plus the TPO.
Thank you, Your Honor.
Grand jury date, January 20, 1/20.
All right, come on. Don't have to, you already got it. All right.
Chandler, Jamar Chandler.
Judge, we can waive probable cause.
All right, Esteban.
Mr. Chandler is 42 years old, Judge. He's a graduate of Aiken High School, also has some college at Sinclair Community College. He was studying entrepreneurship. He also recently started a forklift program through the Free Store Food Bank, was planning on pursuing a career in forklifting. We realize he has a number of prior contacts, Judge, but nothing to indicate that he poses a risk of violence to the community, not even by way of a misdemeanor. He is also able to have an EMD if the court would consider a lower bond for him rather than a high bond. I did note in the police report that they as far as the bond recommendation, the police said they would defer to the prosecution, so it didn't seem like they were asking for a high bond themselves. So we'd ask you to consider a $10,000 bond, Judge.
From the state,
State's gonna ask for no firearms as a condition due to defendant's prior contacts. There are a number of prior contacts. We believe a bond is appropriate and will defer otherwise. We'll ask for EMD if Your Honor does decide to let it out.
there is 1 violent felony, 8 felonies, 6 misdemeanors. It looks like Mr. Chandler was just released from prison in 2025 for drug trafficking. The trafficking in crack cocaine, 15,000 secured. On the, that's the F5. On an F5, 15,000 anyway. On the F4, $25,000 anyway. On the fentanyl, 25,000 secured. On the 131 fentanyl, which is a different day, 25,000 secured. On the fentanyl from January 2nd, 25,000 secured. And on the crack cocaine, which is an F4, 15,000 anyway.
Grand jury date, January 12, 1/12.
Is that on everything?
On everything. Last name Cooper, Kenija Cooper.
Cooper.
You can waive probable cause, Judge.
All right, asked to find.
Thank you, Judge. Ms. Cooper is 22 years old. She is a graduate of Don Community High School. She's also studying business management at Cincinnati State part-time right now and also works part-time at Gold Star. She's denying the allegations here, Judge, but even if taken on their face is true, it appears to me that it's alleged she sold a watch, a rather expensive watch, to a pawn shop. She denies taking the watch or having any knowledge about the watch being stolen. I don't see any record for her. I do see pending driving infractions that were kind of unclear to me in the paperwork I was provided. But based on her lack of context, Judge, and the allegations here, I'd ask you to consider an OR or a supervised OR.
From the state.
State will defer us to bond.
Ms. Cooper has no record. There are 6 pending charges, which are all traffic offenses. There are 4 prior failures to appear, it looks like, on the traffic offenses. And these alleged offenses are from September of 2025. It will be OR plus EMD. The EMD is because of the failures to appear, plus a stay away from, what hotel is this?
Your Honor, I'm not sure. The complaint does not have the name of the hotel listed on it, and I don't have any further documentation from Cincinnati Police at this point.
Not saying you were there, but if you were in a hotel in September, stay away from it. All right? Thank you.
Grand jury date, January 12, 1/12. Last name Dennis, Tariq Dennis. Is there an Aliyah Edie, last name Edie?
Kamal Katsalan for Mr. Dennis, waive probable cause, Your Honor.
All right, Esteban.
Esteban, Mr. Dennis is 19 years old. He's a recent high school graduate of the virtual high school. He currently attends Central State University where he's majoring in business and has a 4.0 GPA. Mr. Dennis's recollection of the events that are leading up to these charges is that Miss Edie owed him money, and she was in the process of paying him back that money, and then I guess decided that she wanted her money back, and as such started making these allegations against Mr. Dennis. He has no record. He's willing to stay away from Miss Edie. He doesn't think that she's even attending Central State anymore either. He has to return back to school on Monday. And he's assured me that he'll be able to return back here. He's given me his mom's contact information too, so that I can make sure that if I don't reach him, I can reach her to ensure that he has a ride back from Central State to here in Cincinnati if these charges continue on. We're asking for OR or low bond here. He's got ties to the community. He's not a big risk, Your Honor.
From the state.
Asking for a stay away, no contact from Aliyah Edie. Allegation is that he exercised control over currency in the amount of $1,349 without Miss Edie's permission. I'm unsure of his juvenile contacts because I don't have access to those records.
As an adult, there's no record, no failures to appear. It is marked on the pretrial sheet that there is one violent misdemeanor. But on the printout, the only adjudication that I have for him is traffic, so that does not appear.
Your Honor, it's in the leads. It's in out of county, out of Claremont.
A misdemeanor assault from 2019. This will be a supervised OR plus a stay away from Aliyah Edie.
Grand jury date, January 20. Herring, Jasmine Herring. Herring.
Thank you.
I saw it earlier, and that's why I looked, because I couldn't find it.
Sanders.
Good morning.
Good morning.
All right. Waive probable cause.
Yes, Your Honor, waive probable cause. Your Honor, Ms. Herring is a nursing student, and according to the allegation, I'm sorry, not a nursing student. She is a nurse, recently graduated. She just started a job at Majestic Care Fairfield. According to the allegations, she received a stolen item. Ms. Herring has told me that her mother passed away in June of 25, and the item in question here was amongst her mother's property that she received and was storing, and then decided that she was going to sell some of that property. Ms. Herring has a job that she started, and has a shift later today. We're asking for a OR or a low bond here.
Is,
Sorry.
thank you. Is there anything from the state?
Your Honor, this, based on the affidavit, firearm was reported stolen out of Butler County in 2018. It was a DPM A15 rifle that the defendant then sold for $225 for rent money. I have no other information. Prosecuting witnesses Roberson's Sports Goods in Butler County.
There is no record, no failures to appear. I'm sorry, no record as an adult. There is a juvenile record, but Ms. Herring is past that look back. There are 2 prior failures to appear in 5 years. No allegations of violence. She is full-time employed. The alleged weapon was stolen in 2018. It is 2025 or 2026, but this was from 2025. It looks like where the weapon was attempted to be sold in December. The allegation for the theft is donuts. The allegation of the threat is beat your ass, not anything with the actual weapon. The supervised OR plus a stay away from.
On the menacing, it's Tia Dunnigan at UDF.
So stay away from UDF.
Yes, ma'am.
Thank you.
Grand jury date, January 20, 120. It's on 21724. Hogan, H-O-G. Oh.
You can waive probable cause, Judge.
Good morning, Esteban.
Regarding bond, Judge, Mr. Hogan is 28 years old, from the Cincinnati area, currently lives with his mother. He is a Don graduate as well. He's in between jobs right now, but he was last employed in a car dealership. Admittedly, he has prior contacts, Judge, but nothing to demonstrate a history of violence. He also does have some failures to appear. We talked about that. He disputes some of them, but promises that he will show up for court on this case and face these charges. I'd ask you to consider a reasonable bond.
From the state,
Our state is requesting a high secured bond and no firearms as a condition. Defendant is already under disability due to multiple felony convictions for drug offenses. I do see that there's a prior conviction for weapons under disability in 2019. With regards to the specific allegations, officers executed a to execute a search warrant of the defendant's residence, located bulk amounts of cocaine and fentanyl, as well as those same narcotics that are intended for personal use, and paraphernalia. According to the incident report the arrest report that I have, defendant's residence also acts as a daycare. So these items were located within the defendant's residence. Asking for a high secured bond, no firearms as a condition.
there are 4 prior felonies, 2 misdemeanors, 9 prior failures to appear. 3 of the felonies appear to be trafficking in drugs. On the having weapons under disability, 25,000 secured. The possession of crack cocaine. Is that F1?
According to the complaint, one of the, these are allied offenses that are charged as both possession and trafficking. I'd ask the court to consider that in imposing a bond on both. However, one looks like it's an F1, the other 2 are F4 and F5, from what I can see.
So the crack on the G and the B are the alternatives that are both F1s.
Yes.
On the F1s, 75,000 secured. On each count. On the F5, 15,000 anyway. On the marijuana OR, that's on both. On the fentanyl F4, 25,000 anyway.
Grand jury date, January 12, 1/12. Last name Justice, Tamaj Justice. Request for an order of protection. Is there a Camilla Bridges?
Waive probable cause, Your Honor. Yes,
Mr. Justice executing the TPO.
yes, Your Honor. Mr. Justice and the alleged victim share a son together, and he's willing to stay away from the alleged victim. We talked about whether or not there are third parties, and he assured me that his parents can work as an intervention so that he can visit with his son as needed. He denies these allegations. He thinks that these are just arguments that they're starting. We talked about the patterns of shared parenting and how behaviors can escalate. He has an ORAS of 2 and a graduate of Doane High School. He has a job that he's been working at McDonald's. He has a shift later today. If possible, he'd love to make that shift. Your Honor, we're asking for a supervised OR and an EMU and protective order here, or anything that the court seems reasonable.
From the state,
State will be asking for a high secured bonds, no firearms as a condition based on the allegations. Prosecuting witness did indicate to officers that the defendant, with whom she shares a child, put his hands around her throat and strangled her to the point of almost passing out. I am not able to see, I don't have access to juvenile contacts, so I'm unsure of those. But based on the nature of the allegations here, we would request high secured bond, no firearms, and juris.
there's no record at all as an adult or juvenile, no failures to appear. The allegations are from December of 2025. And it also is important to note that the officer did not know of any visible injuries, but made sure to put that the allegations that were put in the complaint were received from Ms. Bridges and not anything that the officer witnessed that is typically not in there. OR plus juris if requested.
Grand jury date, January 12, 1/12. Kelly, Lacey Kelly. Kelly.
We can waive probable cause, Judge.
Alright, as defined.
Ms. Kelly's 43 years old, Judge. She currently lives in Claremont County, but she's essentially been in this area for her entire life. She is employed at Norris Flooring. She refinishes hardwood floors, which requires her to travel around to different job sites. Tells me she does have insurance and a license. She had recently purchased a car and the plate was already on that car, so she disputes, intentionally trying to maneuver the license plate. She has no reason to because she has a valid license. She does support 4 children as well. I understand that she does have failures to appear, Judge. I'm asking you to consider not making EMD a condition of the bond, however, just because of the way that her job sites work and the short notice that she has in order to get to those sites. I think it would be difficult for her to comply. She does have a risk assessment score of 2, I would note, and also the highest level felony here is just the 1 count of possession, and it's a felony of the 3rd degree. Other than that, it's a misdemeanor in traffic. I'd ask the court to consider a low bond or a supervised OR.
From the state,
Based on the case history, state will request EMD as a condition of bond defers to the remainder.
you waive probable cause.
Yes.
There's 4 felonies, 1 violent misdemeanor, 4 prior failures to appear on the F3, 15,000 anyway. On the M4 drug paraphernalia OR, on the traffic OR.
Grand jury date 1/12 on all cases. Marcus Moore, MOO.
Mr. Moore is extremely sick, so we're going to ask to waive him and move him to Monday.
All right, this will be continued to, what is Monday? January
The 5th.
Thank you.
Thank you, Judge.
No problem.
Oglesby, Andre Oglesby. Request for an order of protection. 2 requests for orders of protection.
Waive probable cause, Your Honor.
All right, Esteban.
Esteban, Mr. Oglesby is a graduate of Aiken High School. The alleged victim here is his ex-fiancee, whom they share a 20-month-old son together. Mr. Oglesby denies the charges. The same sort of charges were brought almost to the same day last year, and were dismissed for want of prosecution. Is what Mr. Oglesby tells me. Last year, the alleged victim even bailed him out of jail. He denies these charges as he was watching his son the evening that these alleged actions happened. He's a truck driver for Performance Foods. He works every day. He's given me good contact information so that we can stay in touch, and we've started discussing plans of how to avoid these sort of interactions and stay away from the alleged victim completely, while he also has some visitation with his son for the future. We're asking for secured OR, EMU, and a stay away, which he's already executed.
Your Honor, based on the allegations as to the new charges, we would request secured bond and no firearms as a condition. The strangulation and domestic violence are charged together, and I guess in the alternative, I would say. Allegation is that the defendant took the prosecuting witness to the ground, placed an arm across her throat, restricting her ability to breathe. She was able to fight him off and grab her phone, at which point the defendant ran. We would ask, stay away in contact from Katrina Demmons. We would ask for jurors if requested, as well as the high security secured bond and no firearms, given the nature of the allegations. As to the case 13676, that's an older matter from August 9th of 25. same prosecuting witness, we'd ask for the same conditions.
The child was on the first one. I want to address that.
On the strangulation from January 2nd. Let me go through. There's 1 violent felony, 1 felony, 2 prior misdemeanors, 0 failures to appear. There is a safety questionnaire that was completed where the prosecuting witness believed that the defendant will cause serious physical harm. The officer also marked that there was reasonable belief that the defendant was a credible threat to the prosecuting witness. There is an allegation of drinking from the January incident. On the strangulation, 15,000 anyway, plus TAD, plus juris if requested. On the DV, 5,000, this is anyway, plus TAD, plus juris if requested. On the August DV, OR plus juris if requested.
Grand jury date, January 12, 1/12. Does not include 13676, that's not going up.
Pennicamp.
Waive probable cause.
Yes, Your Honor, waive probable cause.
Before you go to bond, does the state have anything on whether this alleged U-Haul was recovered?
I do not have that information. Only information I have indicates that defendant was caught on video taking a 2015 GMC Savannah from U-Haul without permission on November 5th.
Esteban.
As to bond, Your Honor, Mr. Pennicamp owns his own handyman service. He's self-employed. According to Mr. Pennicamp, he rented the U-Haul and returned the U-Haul after hours. And he believes that these charges are, should not be here, so he denies these, of course. He has an honorable discharge from the Navy in 2002. Currently, he's living in Amberley Village with his mother-in-law, who is a member of our esteemed bar for 50 years, Attorney Penny Maines. She's the one who informed him that he had a bond and helped him turn himself in. Mr. Pennicamp has been a pillar of the community since. He's had some interactions and contacts, but he's been moving everything in the right track. We're asking for supervised OR or a low bond here.
From the state.
one prior RSP conviction in 2024. State will ask for a stay away from U-Haul, otherwise we will defer.
There's one felony, one misdemeanor of concern with setting bond. There are 5 prior failures to appear. It'll be OR plus EMD with the stay away from U-Haul.
Grand jury date, January 12, 1/12. Perkins, Raven Perkins.
Thanks, Your Honor. Take a look.
Harvey. Harvey.
Judge, we can waive probable cause regarding,
As to well, hold on. I want to make sure the allegation is reporting of phone. Is that what the allegation is?
the allegation, Your Honor, is that police believe that she reported her cell phone stolen to Verizon in an attempt for them to destroy the data on the phone.
There are no record as an adult, no failures to appear. There's one juvenile assault from 23. Nothing, no allegations is this. This is not an allegation of violence. Is there anything from the state?
No, defer.
Supervised or?
Thank you very much.
Grand jury date, January 20, 1/20. Yeah, Pope, Alfonso Pope. Request for temporary protection order. Three.
That's the 3 in total. Was,
7 DB.
Yeah, should be.
two of them to Reese Talbot.
Jatila Thomas, last name Thomas. The response.
You would have signed it. Judge, Mr. Pope, plea will be not guilty, waiving probable cause. He is willing to execute the protection orders that have been requested.
All right, Esteban.
Judge, as to bond, Mr. Pope does have some holders from Montgomery County and from the juvenile court here, so regardless of the bond today, he's going to be held through the grand jury proceedings. Taking that into consideration, we know these are serious charges, serious allegations, but Mr. Pope is vehemently denying these allegations. He was actually invited over by the PW on this case. There's a lot more context to these allegations. We will address those at the appropriate time. He is a lifelong resident of Cincinnati. He does have good employment at Taco Bell in the area, has steady living. We'd be asking for $10,000 on each charge for each judge.
From the state.
With regards to felony cases, Judge, ending 22657, allegations that the defendant entered into the residence of Jatila Thomas, who is the mother of his children, entered into her residence through stealth without her permission, went into her bedroom, discovered her and another gentleman who I only have listed as a Mr. Smith. He then assaulted Mr. Smith by pistol whipping him, hit the prosecuting witness, Ms. Thomas, and then fled from the residence, taking Mr. Smith's wallet and $150 in cash. We are requesting a high secured bond based on the nature of the allegations, as well as an order for no firearms. We do believe the defendant poses a threat to the prosecuting witness based on their relationship and his ability to enter her residence.
On the aggravated burglary, which is an F1, 50,000 secured. Same on the ag robbery. There's 3 felonies, 3 misdemeanors, 3 pending charges, including 2 domestic violence charges out of county and 3 prior failures to appear. On the misdemeanors, and the robbery and the burglary are felonies of the first degree. Plus jurors if requested. And there was an officer have arm request on these charges as well. On the DVs, 25,000 anyway, plus jurors if requested.
Grand jury date January 12, 1/12. Felony only.
What was the date, sorry?
1/12.
That was
Sloan, Gary Sloan.
The grand jury is on this one.
I'm sorry,
The grand jury isn't on
on
all.
the felony, just the felony.
Right over here in the minutes.
Judges Sloan, the plea will be not guilty, will be waiving probable cause.
All right, Esteban,
Judge, these are non-violent offences and many of them are charged in the alternative, so we'd just be asking for the court to take that into consideration when setting the monetary amount on this. Mr. Sloan has given me good contact information for his family that resides in the area. He is a travelling barber, Judge. He's been doing that for the last 10 years, so he does have a steady income. So we would ask if the court puts E&D restrictions for it to be open hours so he can continue his main line of employment. He does have a history that I'm sure the court has seen, but he has recently successfully been released from parole. It does show that he can comply with the court requirements and court orders if those are imposed. As I said, these are non-violent offences, Judge. We'd be asking for a low nominal monetary amount on these if the court wouldn't consider an ORE.
from the state.
Asking for no firearms as a condition, he has a number of convictions that make him ineligible to carry a firearm. If your honor does decide to let him out, we would ask for EMG lockdown, just based on the number of prior offenses as well as the allegations in this case.
There are 4 violent felonies, 7 felonies, 3 violent misdemeanors, 12 misdemeanors, 0 failures to appear. On the misdemeanors of the 4th degree, 1,000 anyway on each of those. On the F5 trafficking in cocaine, 15,000 anyway. On the B, the F3 on the B, 15,000 secured. On the C, that's an F5, 15,000 anyway. On the D, which is the F3, 25,000 secured. On the traffic OR.
Grand jury date January 12, 1/12. That's on 153 and 154 only. Traffic will not go.
Ulmer, UL.
Judge, this is Mr. Ulmer. He will be not guilty. He will be waiving probable cause.
Thank you. Esteban,
Judge, it's not really a probable cause challenge, but on the two weapons under, I do believe they're for the same firearm. So we would ask that to be taken into consideration when setting bond on these offences. They're not two separate weapons unders with two separate weapons. We'd ask that the monetary bond on those be, kind of combined. For what it's worth, Judge, Mr. Ulmer is an independent contractor. He rebuilds homes, and he's been doing that for the last 7 years. He found this firearm in the course of his work. It was placed in his vehicle. He doesn't usually possess or carry a firearm for any, nefarious purposes, but he found it while he was rebuilding and demolishing and rebuilding a home. And then it was in his car, and he took it with the intent to destroy it, get rid of it, return it to the homeowner. It wasn't the fact that he was, carrying this firearm for safety purposes or for violent purposes. He was just taking it from the residence that he was employed at that time. Mr. Ulmer's last charges stem from 2013, Judge. He hasn't really had any contacts down here in Hamilton County for a long, long time. As I said, he's been working steady employment for the last 7 years, and he has given me good contact information in the area. His mother lives here, and that's where he'd reside if he is given a bond that he can make. So we'd be asking for a nominal bond on these offences, and that's what we'd submit on that, Judge.
what number OBI is this?
First in time, third overall, I believe, with priors in. Let me find them. Hold on. Actually, Judge, I think it's just the first.
I have one prior.
Right, I'm good.
There it is, okay. Yeah, first in time, second overall, sorry, priors in 2006. And I have no further information on the OBI at this point.
Was there an accident?
No accident, no insurance. There is no FRA, so given the prior, I'm gonna ask for a public safety suspension.
There's no ALS, you mean?
No,
Is there ALS?
there's not. And it looks like test was refused.
And is this suspected alcohol or drug?
Believe it's suspected alcohol. Started out as a traffic stop, Your Honor. Turned into an OVI investigation. Defendant was asked by police if he had a firearm in his possession. He denied having a firearm. The weapon was discovered post-arrest during an inventory search of the vehicle. It was a .40 caliber Smith & Wesson handgun found on the driver's side floorboard. Serial had been scratched off. Defendant has warrants out of Montgomery County. Officers served those as well.
On the OVI, OR plus CAD plus no alcohol as a condition of bond, public safety suspension is in place. OR on the failure to reinstate license. The A and the B look like they are the same weapon. I usually do 25,000 secured, so it's 12,500 secured on each count. The CCW, 15,000 anyway. I didn't go over the, there's 4 violent felonies, 2 felonies, 1 violent misdemeanor, 6 misdemeanors, 0 failures to appear. On the improper handling, 5,000 anyway. Possessing a defaced firearm. This is one, OR. Using weapons while intoxicated, OR, open container, OR, speeding, OR.
Grand jury date January 12th, 1/12, all cases.
Whitehead,
Mar Whitehead.
Civic designation. Judge Mr. Whitehead, plea will be not guilty. We will be waiving probable cause.
All right, pass the bond.
Judge Esteban, Mr. Whitehead wants the court to know that he lives in Price Hill with his 1-year-old daughter. He's the sole custodian for this child. Right now, his daughter is with his father. That can't really go on for too long because of his father's work commitments. So he is asking for an OR bond with no EMD attached so that he can get out today to get back to his daughter before daycare starts on Monday. She's in daycare because he works full time. He's been at STNA for the last 7 years. He's currently enrolled at I'm going to butcher this, Hondros, which is a nursing program. It's a 12-month program. He's in the last semester of it. And once he graduates from there, he's going to be a qualified nurse. He's going to continue the path that he's been on for the last 7 years, caring for the elderly in the Cincinnati community. He's a graduate of Hughes High School. He's also a graduate of Job Corps. He got a welding license from them. So he has extensive ties to the community. It's a non-violent offense, Judge. And considering all that we've put to the court today, we will be asking for an OR. And Mr. Whitehead has no problem with a firearm restriction as a condition of release if you can get out today, Judge.
From the state.
One CCW conviction in 2018, we'll ask for no firearms as a condition. Similar to the last case, pulled over on a traffic stop, failed to disclose that he's in possession of a firearm when asked. Inventory search revealed a 9mm Smith & Wesson in a bag located inside the vehicle.
For what it's worth, Judge, there were no bullets in the firearm and the safety was on.
Also accurate.
There's 1 felony, 1 misdemeanor, 7 pending charges of concern with setting a bond are the failures to appear. So I'm not doing straight OR bonds because of the 3 prior failures to appear. On the capious bonds, they were 5,000. Those will be 250 at 10% or alternative OR EMD. On the A and B series, well, actually, on the A, what level is that?
Which case?
The 31705.
Should be unclassified. I don't have any records to back that up, but usually it's unclassified.
250.
I'll do an OR on that one. On the CCW 500 anyway, or alternative OR EMD plus no firearms. On the other 2, the signal and the driving under OR.
Grand jury date January 12th, 1/12. That's
Sorry.
on cases 151 and 198, January 12th.
The bond on the CCW is 500 anyway.
Yes.
Sorry, just didn't write down.
Misdemeanor lockup docket, Allen.
request for an order of protection.
Good morning, Your Honors. The plea is not guilty on behalf of Mr. Allen.
Name of both lines?
On Allen. Is there anything from the state? Mr. Allen has no record as an adult or juvenile, no failures to appear. It does look like there may be some pending juvenile with no dispositions.
This appears to be a fight between cousins. Leandre Dorsey is the prosecuting witness, last name Dorsey.
Herman behavior.
No response. Asking for a stay away from Leandre Dorsey, and we'll defer as to the protection orders requested.
Is he gonna execute the TPO?
He has, Your Honor.
Be the OR plus a stay away.
Barham.
What number? OBI.
Second in time, second overall, priors in 2024. No accident, insurance was not demonstrated. All tests were refused, and there is an ALS on file.
Both priors in 24? No, second.
This
One
is
prior.
the second, there's one prior.
Second in time, second overall refusal, I'm sorry, insurance?
No, no accident. Yes, ALS.
All right. Esteban,
Yes, Your Honor. The plea is not guilty. On behalf, we would be asking for an OR bond. He is a graduate of Atlanta Area Tech and Communications and Marketing. He has a daughter who is in the Air Force, and he also helps support his niece and his nephew, who he is also a Little League football coach for. He has maintained a stable job for 7 years at the U.S. Postal Service. I have explained to him that he cannot drive, and he understands that this is a nonviolent allegation. He doesn't pose any danger to the community. With significant ties to the community and not posing any danger, we do think that an OR would be appropriate. I have good contact information for him. I have a stable address and a backup contact information. I'm confident that I'll be able to make contact with him as well.
is there, what number driving under OBI suspension is? Do you know?
Appears to be a first. Yeah, I think it's a first.
All right, Esteban,
Your Honor, we'll ask for a TAD monitor, given it's a second and it's a relatively close second, so other than that, we will defer.
there's one felony, 3 violent misdemeanors, 4 misdemeanors, one prior failure to appear. OR on the red light, OR on the driving under OBI suspension, on the OBI, OR plus TAD plus no alcohol is a conditional bond. This case is assigned to me. I have put on the judge's sheet that if any alcohol is detected whatsoever, that they are to bring me a warrant immediately. No alcohol is a condition of bond. Are we 100% clear on that? sir?
Yes, ma'am.
All right, thank you.
Bates, BAT, Bates. Request for an order of protection for Julia Denton. No response.
All right, that's
Yes, Your Honor, the plea is, sorry, the plea is not guilty. As for the TPO, he's willing to sign it as to the alleged victim, but his children are on here, who have no connection to the allegations in the incident, so we would ask that they be removed. They share custody. He wants to see his children as any parent would.
on the state.
Your Honor, state would object to any modifications on the temporary protection order at this point. Allegations are that the deputies responded out allegations occurred on December 30th. A few days later, after deputies responded out to defendant's residence for a welfare check called in by members of the prosecuting witness's family, concerned for her safety. When they arrived there, prosecuting witness reported to them that on December 30th, the defendant had struck her in the face and also made threats to kill her. I don't have any further information regarding the children or their involvement at this time. However, due to the allegations and the fact this was called in by members of the victim's family, I'm going to ask that they remain on. It can be readdressed at a later date once further information is learned.
I will take the kids off. There's no allegation against the children and no allegation that they were there. There's 2 felonies, 4 misdemeanors, 0 prior failures to appear. The prosecuting witness filled out a safety questionnaire stating that she believed she was safe in her home. And if I'm making sure I'm correct, someone else called the police to report an alleged incident that happened a couple days before, correct?
I don't know.
They weren't called to the scene
They were not called to the scene that night, no.
OR plus juris if requested.
Bowman, BAU, Bowman. Order of protection requested. Last name Floyd. Your response.
Same thing for the children, Your Honor, on this case. The plea is not guilty.
That's fine. That's fine. I mean, just no, they can stay on there because that way I can guarantee that we don't have to interact. I like that. Yeah,
I'm not taking the kids off because they're part of the allegations.
Okay,
Yeah, I want to stay them on that way. We don't have to communicate to each other. I don't want no
Okay,
excuses for nothing at all.
All right. Esteban.
yes, Your Honor. He is the father of 5 children, twins, a 10-year-old, a 6-year-old, and a 5-year-old. He has been taking care of these children since the prosecuting witness of this case dropped them off at his house and just left them for an extended amount of time. We believe this incident, this allegation came as kind of like a revenge kind of reporting of something after she left her kids to be taking care of their father. She arrived and was cussing and yelling at the children. This incident, he has no records of violence. He has an ORS score of 2 and only 1 failure to appear in the past 5 years. We would be asking for a reasonable bond in this case. He is a high school graduate of Aiken and Woodward, but is struggling to find employment at the time, and so is not in a financial position to do that. He is not a danger to the community, and I have good contact information with him where I'm sure I'll be able to stay in contact. Very willing to sign the TPO.
From the state.
So request juris on this one. Allegations that while prosecuting witness was parked in the driveway for child drop-off, the defendant approached her vehicle. She rolled the window down. He then struck her through the window, punching her in the face and causing a split lip.
Oh, if I may briefly, Your Honor. I
So
apologize.
ask for juris.
My hands.
Hold on. Just let your attorney talk.
Yes, Your Honor. Sorry, I meant to add, he actually was bitten on his finger and it was bleeding, and that was probably where the blood in her mouth came from because she bit him.
There's no record. There's 1 prior failure to appear. There's 6 minor misdemeanors, but no other convictions, felonies, and misdemeanors. There is a safety questionnaire where the prosecuting witness expressed fear of harm. The officer believed there was some type of credible threat. Based on the TPO being executed and no record, no history of violence, found to be OR plus juris if requested.
Thank you. I appreciate it.
Thank you, sir.
Crane, Jessica Crane.
Morning. The plea is not guilty, Your Honor. Okay.
Does Ms. Crane have somewhere to go on EMD?
Yes, she does.
Is there anything from the state?
No.
All right. These are mine. There are 7 prior failures to appear, but I noted at the time that I capious her that she was capious because she was in jail in Kentucky, and I would have checked that before I wrote it down. So the bonds will be OREMD.
Yes, Your Honor.
Crawford.
That's it, Your Honor. Have a good weekend.
You too. Thank you.
Good morning.
Crawford.
Yes.
I never had that. What are the charges? Because I'm looking for cover sheet.
You
Is it just traffic?
It is an OBI, unreasonable control of driving under suspension.
Please would be not guilty, Judge.
All right. As to these are 3 warrants from 2015.
Yes, Judge. And Ms. Crawford has picked up no charges since. She works at Olive Garden. She's been doing that for almost a year, Judge. She has 2 children, a 16-year-old and a 15-month-old. We'd be asking for an OR. She has had contacts with police in the past 10 years and has never had a warrant pop up for her. I believe she will stay in good contact. Okay.
From the state. These are from 2015, nothing else.
Nope, I'll defer.
And she already did at least the dip days that were assigned in 2015. Oh, wow.
Condon. Yeah.
Yes.
A for B. Wait, did I dismiss B?
Yeah.
What are we doing? 2 traffic offenses, Your Honor. I believe we've reached a resolution. With the court's permission, we'll accept a guilty plea on the A, unclassified driving under suspension, and dismiss the B.
Mr. Cundiff, a guilty plea is a complete admission of guilt. This is an unclassified misdemeanor. Maximum possible penalty is up to $1,000 in fines and costs, up to 500 hours of community service. You do have the right to a trial. Knowing your right to trial, the maximum possible penalties, do you want to maintain a guilty plea to 1 count of driving under suspension?
Yes.
Counsel, do you waive the stipulate?
Yes, waive the stipulate.
Finding of guilty, he's been there for 1 night.
Yes.
Is there anything else?
He has 2 children who he helps support. We'd be asking for time. And remember.
State, was there FRA?
I looked at it and then I forgot. No.
Was there an accident?
Also, no.
No.
All right, 1 credit, 1 remit the fines and costs.
Galloway.
Galloway!
Oh, so this is you. Makes it lighter.
The pleas are not guilty.
David. You please, road.
Like skip over and recall him.
That's fine. Garnett is next.
Judge, Mr. Burnett is represented by Emily Madosh, so I will be representing him today just for this EMU violation.
Okay, all right, this is not a new charge. This is the EMD.
Yes. We would be entering in a guilty plea to the violation.
All right, as to a bond.
Yes, Judge, we would be asking to either change his bond to 1,000 at 10 or to reinstate EMU. Judge, it's my understanding Mr. Garnett has no record but one juvenile misdemeanor and 0 failures to appear. He did not go to the prosecuting witness's home. What we talked about in the back was that he did not understand all of the rules around EMU, and he was under the impression he had open hours, and he does not. He is a full-time student at Tiffin University. He graduates in the spring. He's a receiver on their football team, Judge. We have gone over all the rules. I've explicitly told him that Miss Madosh, if he wants open hours, is going to have to go in front of the judge and ask the judge to do that. So we would be asking to either 1,000 at 10 or reinstate EMU.
When does school start back?
January 5th.
So how is he gonna do EMT up there?
Miss Madosh is gonna have to go in front and ask for hours for school.
He can make 1,000 at 10%?
Yes, he can.
He has no record as an adult, no failures to appear. There's one misdemeanor, which is a nonviolent disorderly conduct. Is there anything from the state?
Your Honor, we would object to changing the original bond this time or removing EMD. The underlying charge is domestic violence charge. Prosecuting witness has not been consulted about this. Nothing further.
Again, Judge, I'd like to reiterate, he didn't go to her home.
Well, the original, does she have jurors?
It's not my understanding that she does.
Let's recall this because I have 1,000+ jurists. I don't have an EMD on here.
Okay.
So if he was on EMD, then there was an order for EMD. So there should be a jurist. Yeah, there has to be a jurist on it because there was not an EMD order. Did they give you a radius that you have to stay away from?
Yes, ma'am.
All right, there's a jurist. All right, it'll be the same bond with the EMD and jurist. The EMD is open hours. Defendant may, where's Tiffin?
About like Toledo, Findlay, Ohio. So.
Defendant may go to school.
And we would ask for football practice as well, Judge.
It's open hours.
Oh,
I'm
open
just
hours, that
saying
is what
he
you
can-
said,
Yeah,
sorry.
he can leave Hamilton County.
Okay.
So if you come back into Hamilton County, you still are bound by that radius.
Okay, yes,
So
ma'am.
you
That's
can go anywhere, anytime, except within that radius.
Yes, ma'am.
All right?
Yes, ma'am.
Thank you, Judge.
So,
We'll talk back. I'll come back to you.
Are we ready on Galloway or do I need to keep going? Deputy. Throw a pen in it. No.
I think he just asked about.
Galloway, okay.
That's what I needed to know.
Yes, you got the numbers for your city.
Okay.
The plea would be not guilty.
I'm sorry, is this Mr. Galloway?
Yes, Judge.
Okay. Is there anything from the state?
No.
We'd be asking for an OR, Judge. Mr. Galloway is affiliated with GCB in the community and needs to keep taking his medication.
There are 7 prior failures to appear, so I'm gonna put EMD on, but it'll be open hours.
Based on my arrest report, defendant may have full extradition warrant out of Butler County. Is there a holder that you know of?
I did not see one.
Okay. Defendant has a full extradition warrant out of Butler County. That's initially what they were trying to figure out. At least based on my arrest report. He also had additional warrants out of Hamilton County.
That was based on the complaint. It said that the name on the complaint is the one that had an extradition warrant.
Okay.
So it's not my understanding that it's Mr. Galloway's name that has the warrant attached.
Got it.
OR EMD.
Okay. I'm gonna come in the back and talk to you, okay? So you're gonna step in the back and then I'm gonna come talk to you.
And
Yeah, he's gonna take you. Okay, so you're gonna walk with him and I'll come talk to you.
Hinton, H-I-N.
He's right there. He's Thomas.
Right here. Take your turn.
Is this okay right here, Your Honor?
Yes, sir. You can stay there, Mr. Henry.
The plea will be not guilty, Judge.
All right, Esteban.
As to bond, Judge, Mr. Hinton is 69 years old. He's from Cincinnati. He only has one other misdemeanor on his record, Judge. We would be asking for an OR bond. I am planning on getting reconnected with the social work team through our office.
From the state.
State will be asking for a stay away from all Kroger stores. Allegations are that the defendant approached one of the Kroger store managers and advised that he had placed a bomb inside the store. They had to evacuate the building and search it. So we'll ask for a stay away from Kroger. If he has a place to go on EMD.
Does he have somewhere to go on EMD?
It's my understanding that I don't have contact information for someone to verify.
Does Mr. Hinton have contact information for you to get a hold of him?
He has told me that he has a new phone number, and I had given him my card, and I told him to contact me when he gets out, so I have his number.
Mr. Hinton, do you understand what your responsibilities are when you get out?
Yes,
So you have to call me?
yes, but
Okay.
I'm suffering from mental illness.
All right, hold on for 1 second. I just want to make sure that if you get out, that you know how to get a hold of your attorney so that you can get back here. All right?
Yes, ma'am.
All right, and you know you can't go to Kroger.
Yes, ma'am.
All right. Supervised OR.
Hubbard, Brandon Hubbard. Quinetta Thornton. No response.
Judge, the plea is not guilty on behalf of Mr. Hubbard. As to bond judge, he indicates to me that he actually has a parole holder. I didn't see that in my paperwork, but I do trust him when he says that, so I would just ask for a nominal bond at this point.
Is it? Oh, it might be a federal.
I believe it is.
Okay. Yeah. From the state.
State will ask for no firearms as a condition of bond. Stay away, no contact from Quinetta Thornton and jurors if requested. Allegations are that the defendant struck the prosecuting witness in the face with an open hand, spit on her, and then attempted to strangle her. Defendant does have prior felony contacts involving weapons, including weapons under disability, as well as robbery specification.
There is a record, I'll do 1,000 plus jurors if requested, but based on there being a federal holder, I don't anticipate Mr. Hunter getting it. All right. But there is a stay away in place, meaning that you cannot make phone calls, stay away and no contact, that you cannot make phone calls either. All right? Jones.
That's it.
Deandra Jones, Sir Kiera Booker,
Judge, the plea is not guilty on behalf of Ms. Jones. As to bond judge, Ms. Jones is 40 years old. She is a mother to 7 children, 6 of which reside with her, Judge. Their ages range from 21 to 9 years old. Judge, she is on disability. She's on a fixed income. She has terminal cervical cancer. She does have regular treatments where she gets infusions for that. Judge, I show 0 failures to appear, an ORAS score of 1. She denies the allegation here. She does not know this person. She was only present in the area for the menacing because she was picking up her nieces, who I think were involved in some dispute with Ms. Booker. She's not sure how she ended up being the one that got a charge here. As to the unauthorized use of a motor vehicle, she was in contact with CPD to report that the U-Haul was stolen from her. I think that we will be able to verify that with CPD, that she reported that. They did find the U-Haul somewhere in Newport. So I'm confident that that is actually not really going to turn into anything serious. Judge, I would ask you to consider an OR on both of these.
From the state.
asking for a stay away from Kiera Booker. It's on the county charge, 4605 Montgomery Road, which is the Walgreens in Norwood.
And from the city, asks to stay away from Harry Pizzle on the unauthorized use.
OR plus stay away from Walgreens and U-Haul.
Thank you, Judge.
There are no failures to appear, 2 violent misdemeanors which appear to be threats, and 2 misdemeanors, nothing of physical violence.
Thank you, Judge.
Brandon Robinson.
You have a seat right there on my bench.
Nope, he's back there.
He's back there.
What was last?
Robinson. He's got like a black jacket on.
Where'd he go?
It's in between all the other calls.
Judge, the plea is not guilty on behalf of Mr. Robinson. As to bond, he's 46 years old. He is a father to 3 children of his own. They're aged 19, 18, and 14. Judge, he does live here in Cincinnati with his girlfriend and his aunt. He works as a machine operator. He's been doing that for 9 years. Judge, I show 0 failures to appear, an ORAS score of 2. Last meaningful contact with the system was somewhere around 2019. Judge, it's my understanding that the prosecuting witness has some severe behavioral issues that have been documented by doctors. I believe Mr. Robinson and his girlfriend, who's the mother of this child, have been working to figure out how to take care of this child, how to help this child. Mr. Robinson indicates to me that this child has tried to burn their house down on multiple occasions. And so I think that we will be able to get documentation of these occurrences and of the risk that the child poses to himself and also to the people around him. Judge, it's my understanding as well that JFS has already removed the child from the home. I did speak to Mr. Robinson and let him know that he will likely be able to have no contact and have to stay away from that child. He understands that and is able to do that. I would ask you to consider an OR bond.
From the state.
Allegations are that the defendant restrained the 9-year-old child in question by strapping him to a chair while he left for the gym. Officers responded out for a welfare call from the child's, I believe, older sibling. Indicated to officers that the defendant had strapped her younger brother to a chair prior to leaving the residence. When they entered into the residence, they did find that child as well as a 5-year-old unattended in the residence. The 9-year-old was restrained by a leather strap to the chair, indicated that the defendant had placed him there, quote, because he was being bad. Child was removed by JFS.
$15,000 anyway, plus juris if requested. There's 1 felony, 1 violent misdemeanor, 0 prior failures to appear. The child has been removed, so there is, at this time, not a threat of harm to the child from the defendant. There is also a no contact order in place unless there is JFS supervision.
Judge, can you give me the monetary amount one more time, please?
$15,000 anyway.
Would you consider an alternate OR EMU for this?
I won't.
Okay.
County walk-in docket, Zaire Smith. Defendant's present approaching the door.
And Tavion Beal, do you have that one next?
I do.
Tavion Beal. All right, come on up, Mr. Beal. Did she make the bond or was she
posted bond? This is Zaire Smith, correct?
Good morning, Ms. Smith. Is there anything from the state?
No, Your Honor.
All right, it'll be the same bond that you already posted, the standard bond. All right. You'll go get your next court date, and then you have the diversion paperwork. All right?
Okay.
What room?
117.
117. All right, just through there.
Down the hall on the left.
Stop at the window and then
Good
go
morning,
across the hall to
Mr. Beal.
117, okay?
And did I set this?
I do not have any paperwork.
Yeah, that's
This is wrong. This is sorry. I'm saying it's wrong.
I do not have any paperwork on it. I can go run it.
Mr. Beal is here today. This is a 25 charge. It'll be supervised. Go get your next court date, sir. Okay?
And that completes the county's docket.
Moving on to the city lockups.
I will see you the rest of the week because this is where I am.
Who's your permanent home?
Now, grand jury is starting a rotation where we do this every 2 weeks, and now I'm in grand jury division, so.
Oh.
All right, Leslie Klein.
So we won't have them.
Leslie Klein,
I got a quick question. So on this one, which is like more, which is the guy's name is like all supposed to.
Good morning. Gianna Bunting on behalf of Mr. Klein.
Yeah. Yeah.
All right. As to,
Yes, as to bond, Mr. Klein is 54 years old. He does live here locally in Cincinnati with his mother and his wife. I have good contact for his wife as well as for Mr. Klein himself. He does have 2 children under 18 that live with him that he takes to school and takes care of. He does receive disability. The disorderly conduct is a misdemeanor of the 4th degree. I do see that there's a bond. From my understanding, there was some miscommunication between Mr. Klein and his attorney about that date. And it's also my understanding that the sentencing was pushed in order to get the restitution, which being held, Mr. Klein is not going to be able to do. So we are asking for an OR bond. The other 2 charges are traffic matters. So we are asking for an OR bond on that, or SOR.
is there anything from the state?
The state, we would ask to stay away from prosecuting witness Lucy Johnson and diffuse the rest.
OR on the driving in the traffic light violation on the other, it was a theft reduced to a DC. It looks like there was a court date to pay the restitution. The judge has put a bond on here with no recite and no recall on it. When the judge is specific as to their bond, I do not change.
The court consider an OR EMU alternate.
Raja Davis.
Please not guilty for Ms. Davis.
There are 2 misdemeanors, 2 pending charges, 3 prior failures to appear. Does Ms. Davis have somewhere to go on EMD?
Yes, are you able to do EMD? She's currently at Lighthouse, Judge, and actually just got a bed set up there. She's with our social work team. I believe that you can do, are you able to be on the box at Lighthouse?
Oh, no. I got work tonight.
I believe we can get her on EMU at Lighthouse.
Is there anything from the state?
That's to stay away from Maya Yana.
Ms. Davis, you have some failures to appear. I am going out on a limb because this is a nonviolent offense. You have a minimal record and doing a supervised OR. You need to make sure that you stay in contact with your attorney and that you show up. You're at Lighthouse, which means that you have an opportunity to get permanent supportive housing.
Yes, ma'am.
You have a job. So everything going forward is up to you. So you need to show up on this case so that you can keep your housing and you don't go to jail. I'm not putting the EMD on it so that you can go to work.
Thank you.
But if you don't show up, then you probably won't get that chance again. So please make sure that you stay in contact with your attorney, all right?
Yes, ma'am. Thank you so much. Okay, thank you. Have a blessed day, y'all.
The pleas are not guilty for Mr. Prater. I submitted Paul Slater's designation. He does represent Mr. Frater on another case. Mr. Frater is 21 years old. He does live here locally in Cincinnati. I have good contact information for him as well as his mom, who he can stay with during the pendency of this case. He graduated from Queen City Career Prep. He has 0 failures to appear. He has 1 minor misdemeanor conviction. I see nothing in his juvenile or adult record. We are asking for an OR or an SOR in this case, based on the minimal record and 0 failures to appear.
From the
From the
state.
state, we'd be asking for the monetary bond. There's 2 allegations of assault on the same victim that occurred within 3 weeks of each other. The allegations on both are that defendants struck the victim during a verbal altercation. There's also a criminal damaging based on allegations that the defendant took the victim's car keys and snapped them. Based on the allegations, the state would be asking for a monetary bond as well as a stay away order.
Mr. Frater has no record as an adult or juvenile except for 1 minor misdemeanor. There is 1 pending charge, 0 failures to appear, OR plus juris if requested.
Thank you, Judge.
Thank you, Judge.
Thank you. Gibbs.
Mark Gibbs.
Okay. So please not guilty for Mr. Gibbs.
Was there actual contact between the parties? I have an attempt.
Not fixed.
Judge, the language I have in the complaint and the arrest report is that he attempted to assault victim with cane.
How close do these folks live from one another? And to one another?
She lives on
Hold
the
on.
4th floor and I live on the 2nd floor.
Okay, thank you.
4th floor, sorry.
All right. We have the answer now. Is there anything from the state?
We defer to the court, to be honest.
Supervised OR, plus stay away, no contact, Mr. Gibbs.
Yes, ma'am.
If you see your neighbor, just walk the other way.
Yes, ma'am.
You're not allowed to have any contact with
Okay.
her unless your bond can be revoked. So you're not gonna have to pay anything to get out. But if you say something to her, then you can be brought back in
I
and
totally
then
understand.
be held on something else,
I
okay?
totally understand.
Thank you, sir.
Jordy Harris.
The plea is not guilty, Your Honor. As to bond, Mr. Harris is a lifelong Cincinnati resident. He is currently struggling with housing, but we will put in a social work referral and get him connected with services. He does have medical conditions, which he does take medications for, so we just want to ask for an OR bond to make sure that he can continue at the shelter he's currently at and continue taking those medications.
From the state,
Judge, from the state, officers are asking for a high bond in this case. The allegations are that The arrestee refused to exit off the street car after faking a seizure and then fought with violent police officers after being given multiple warnings to exit. Arrestee kicked and slapped officers and violent personnel until arrestee had been maced and placed in handcuffs.
There's 4 felonies, 1 violent misdemeanor, 11 misdemeanors, and of concern with setting bond, 15 prior failures to appear. There's a request for a high bond based on the allegation that an officer was kicked and slapped and fire personnel was kicked and slapped. 1,500 anyway on the criminal trespass, 25,000 anyway on the resisting.
Caller Hewley.
Julie?
Sorry.
You got a lot going on. Miss
Yes,
Hewley.
can you please let me go home?
Good morning.
Hi, good morning, how you doing?
I'm good, thank you. All right, there's 2 pending charges, 1 prior failure to appear, no convictions as an adult or juvenile. Is there anything from the state outside of a stay away?
Outside of stay away, nothing to do.
All right, Ms. Hewley, stay away from Meijer. Don't go in any Meijer store. I'm here all week. If you go back to Meijer and you back in here, you're not gonna leave on another.
Miss Lady, I'm
Hold on,
not.
hold on.
I'm sorry.
Hold on, just listen. Because I'm about to give you an OR bond, so don't talk your way into paying, all right? So it'll be a supervised OR bond. What I'm telling you is that I won't do it again if you go back to Meijer, all right? So just stay out of Meijer stores until this case is done.
Okay.
All right, supervised OR, stay away.
Thank you, guys.
Next, Rebay Miles.
The plea is not guilty. As to bond, Mr. Miles has a CDL with a Class A, so he is currently employed as a truck driver. He graduated from Dawn High School, has attended trade school, and has numerous construction certificates. He is currently living with his mom. He has 2 dogs at home. One is a Belgian Malinois, sorry. A larger dog. His mother is unable to take care of that dog. So we would be asking for an OR bond on this. He has good contact with me. I have his number, a good address. One of the issues with that prior failure to appear was that his previous attorney was sending mail exclusively. As he is a truck driver, he is moving often, but always coming back. But because it was by mail and not through text, which I will be engaging with him through text, we'll make sure to have everything very well scheduled in advance so that he can make his court dates.
Where is Mr. Miles going to stay if he gets released?
At the address listed, 5642 Prosper Ave.
That, where, what address?
Prosper Ave. Prosser. Ave.
Okay, so not this Reading Road?
No.
He would have no problem staying away from the PW.
Well, that's what it has on here, that they reside together. That was my concern. He's not going back to the same
No, I'm not
place.
going back there.
From the state.
Nothing for this one, state, Your Honor.
There's one prior failure to appear. There is one felony, 7 misdemeanors, 1 violent misdemeanor. The violent misdemeanor is not physical. It was a M4 menacing threat. OR plus stay away from Stephen Young.
Shaquilla Rowe.
Just stay right there.
The plea is not guilty. As to bond, Ms. Rowe has 2 children at home that she is the sole provider for. So she is they're young as well. It's 9 and 11 are her kids' age. We have good address and good contact information. So we would just be asking for an OR bond or in the alternate EMU.
From the state.
State, we would get the court.
Does it say how far the stop took?
I don't believe I have that information, Your Honor.
And there's no bond request?
None from the officers.
There's 3 prior failures to appear, 2 prior felonies. It'll be OR plus EMD with the 3 prior failures to appear. And I will do EMD open hours since she has the kids, probably has to take them to school. Strobel. Are you just asking for a nominal bond because of the parole holder?
Yes.
Plus stay away, no contact. Who does he need to stay away from?
Savannah Kramer.
1,000 anyway, plus stay away, no contact. There's 0 prior failures to appear, but there is a felony parole holder, which is going to keep him in. All right.
And on to city walk-ins.
We're just gonna call these out because no one is here. All right. Neil Boggs.
Over.
Neil Boggs, do you have paperwork? You know I have paperwork. $1,000 anyway. 1,000 anyway. William Bolt. KPS 1,000. KPS OR on the seatbelt. OR. KPS OR on the seatbelt. KPS OR on the license plates. Lindsay Curtis, KPS 1,000. Brandon Sears. This is the second KPS on this case, KPS 2,000. On the disorderly conduct for Sears, it's the first KPS 1,000. On the pedestrian violation, KPS 1,000 or alternative OR EMD. On the trespass, this is the third KPS for Brandon Sears on that charge, KPS 3,000. That is the docket. Thank you. Yes, if you would. Thank you very much.
She did.
Okay. Oh, wait.